Yes, we are talking about the dying declaration. I know reading the Bare Acts can sometimes feel a bit dry, but today we're going to break this down step by step so it permanently locks into your memory. Notebooks nikal lijiye, keep your eyes on the screen, और चलिए शुरू करते हैं. Okay, let's dive into this with a really simple question. हम सब ने वो dramatic, घंटे भर लंबे Bollywood death scenes देखें, right? The hero gets shot, gives a 15-minute emotional speech, hands over all the family responsibilities, maybe even sings a quick song, and then finally passes away. But honestly, do dying declarations actually work like that in a real courtroom? Today, we are going to separate that cinematic drama from the strict legal reality. So, here is our syllabus for today's explainer. We'll be looking at the concept and its maxim, the relevant legal provisions you need to know, the essentials for validity, important case laws, evidentiary value, and we'll wrap up with a quick exam revision. Moving right into Section 1, let's talk about the concept and the Latin maxim. What exactly is this concept, and why does the law take it so incredibly seriously?
ध्यान से सुनिए. A dying declaration is simply a statement made by a person who is now dead, explaining exactly how they died or the circumstances that led up to their death. Let's take a practical example to make it crystal clear. Imagine Ravi is stabbed near the local market. Before passing away, he tells a bystander, Amit stabbed me because I refused to lend him money. Here, Ravi's statement explains the exact cause and the circumstance of his death. Because Ravi actually passes away, this statement becomes a valid dying declaration in the eyes of the law. Ekdam clear?
Now mark this next point with a star for your exams. You absolutely must know this Latin maxim, nemo moritoris presumitor mentiri. Note this down right now. It beautifully translates to, a man will not meet his maker with a lie in his mouth. You see, the law presumes that when a person is literally on their deathbed, facing divine judgment, the chance of them lying is practically zero. They're speaking the truth because they have absolutely nothing left to gain from telling a lie. So the most crucial takeaway here is that a dying declaration is a massive exception to the hearsay rule. Normally, courts do not accept hearsay, or what we call kani suni bate, because you obviously can't cross-examine the original speaker. But the law allows dying declarations for two very logical reasons. First, sheer necessity. The victim is often the only eyewitness to their own murder, and we can't let justice fail just because they aren't here to testify. And second, as we just saw, there's that incredibly strong presumption of truthfulness at the time of death. All right, Section 2, relevant legal provisions. Now that we understand the philosophy behind it, let's look at the exact sections of the Bare Act that you need to memorize.
Guys, बहुत important update है. Under our new criminal laws, the dying declaration is now governed by Section 26, specifically Clause A of the Bhartiya Shakshya Adhiniyam, 2023, also known as the BSA. For those of you who spent hours studying the old laws, please remember that this completely replaces Section 32(1) of the Indian Evidence Act of 1872. Make absolutely sure you are quoting Section 26A BSA in all your upcoming subjective papers.
Now for a major exam tip. Examiners love asking about the difference between Indian and English law. Listen closely. In English law, the victim must strictly know they are going to die. They must have a clear expectation of death for their statement to be valid. But under Indian law, the expectation of death is not required. Even if the victim confidently thought they would survive, but unfortunately died later, their statement is still completely admissible. Plus, in India, this applies to both civil and criminal cases, not just murder trials like in England. Let's move to Section 3, Essentials for Validity. What exactly makes a dying declaration legally bulletproof when you step into a courtroom? Here is your ultimate checklist for validity. First, it doesn't even have to be a formal written document. It can be oral, written, made through simple gestures, or, hey, even recorded on a smartphone video. Second, it must directly relate to why or how they died. Third, and please don't forget this, the person must actually die. It is a mandatory condition. And finally, the statement has to be completely voluntary and given while the person is mentally fit and conscious, not under any pressure, and definitely not tutored.
Another high-value exam tip coming your way. सोचो अगर हमारा बॉलीवुड हीरो एक dramatic dying declaration देता है, but then miraculously survives that fatal gunshot. What happens then? The law is simple. If they survive, it is no longer a dying declaration. Why? Because the maker is alive and well, and they can easily walk into court to give regular evidence. That past statement can now only be used to either corroborate or contradict their live testimony in court.
On to Section 4, important case laws. You literally cannot write a good judiciary mains answer without citing landmark case laws. Let's look at two of the most critical Supreme Court judgments. First up is the legendary Pakaya Narayan Swamy case. Is case mein kya hua tha? A man simply told his wife he was going to collect money from the accused. He obviously didn't know he was going to die. He never returned and was unfortunately found dead later. The court held that his statement to his wife was a perfectly valid dying declaration because it explained the circumstances of the transaction that eventually led to his death. The second one is Queen Empress v. Abdullah. Here, the victim's throat was tragically cut. She couldn't speak at all, but she answered questions by nodding and making gestures. The court ruled that yes, gestures and nods are perfectly valid dying declarations. That brings us to Section 5, evidentiary value in court. We know what it is and how to validate it, but when we actually stand before a judge, how much power does this piece of evidence really hold? Let me pose this direct question to you right now to test your legal instincts. Imagine a trial where there is absolutely no murder weapon found, no eyewitnesses, and zero CCTV footage. The only piece of evidence the prosecution has is the victim's dying declaration. Can a judge actually send the accused to prison based solely on that one statement? The answer is a resounding yes. The Supreme Court in the landmark Kushal Rao v. State of Bombay case laid down the golden principles for this. A dying declaration can absolutely be the sole basis for conviction, bina kisi doubt ke. There's no absolute rule that says it requires backup or corroboration. However, the court did warn that it must be 100% true, reliable, and voluntary. If it passes the strict test of authenticity, it is powerful enough on its very own to secure a conviction. But hold on, courts are not blind. They test the quality of this evidence very rigorously. A court will straight up reject or demand corroboration if the victim's mental fitness is in doubt. Imagine if a person gives 3 different statements naming 3 different people. Those contradictions completely destroy its value. Similarly, if the judge suspects the victim used their last breath just to falsely frame a rival out of pure malice or revenge, the court will dismiss it immediately. Finally, Section 6, quick exam revision. We've covered a ton of ground today. Let's pull all these concepts together so you can take a mental screenshot for your exams. 1 minute mein revise karte hain. Here is your 1-page revision checklist. Memorize these 5 points. Number 1, always quote Section 26A of the BSA 2023. Number 2, drop the Latin maxim in your answers. Nemo moratoris praesumiter mentiri. Number 3, highlight that Indian law does not require the expectation of death. Number 4, emphasize that death is absolutely mandatory for the section to apply. And number 5, state confidently that under the Kushal Rao principles, it can be the sole basis for a criminal conviction. And that brings us to the end of our explainer. But I want to leave you with one final provocative thought. We know oral statements and head nods count, but as our digital world evolves, can a rushed WhatsApp voice note, an Instagram live stream, or perhaps even a specific emoji sent right before a tragic event be accepted as a valid dying declaration in the courts of tomorrow? The law is constantly catching up with technology, and it's a fascinating space to watch. Thank you so much for joining this whiteboard masterclass. Keep studying hard, and I'll see you in the next explainer.